So now we begin with the case law, that is Meriwether versus Nixon. Meriwether versus Nixon. This is a landmark where court laid down that in the common law, a wrongdoer cannot maintain an action for contribution against another wrongdoer, even when the one seeking contribution would have satisfied the full claim of damages. And this is popularly known as the Meriwether versus Nixon rule. This is a rule. This rule of the Meriwether versus Nixon existed and had a wide applicability, but it existed with certain exceptions. Now, this is in Hindi. You can have a look. अब आके देखते हैं हम लोग. This is the fourth. Right of the tort feasors. Tort feasors के rights क्या क्या होते हैं? Interest, contribution and indemnity. If one of the joint tortfeasor has been made to pay more than his share of damages, he can demand contribution in respect of the same from other wrongdoers. Please pay attention over here. Other wrongdoers. Okay? The contribution can, however, be demanded only from the tortfeasor. Point to be noted. Who is liable in respect of plaintiff's damage. The amount of contribution recoverable from any person shall be just and equitable, having regard to extent of his responsibility for the damage, appointment of liability. There may be situations where the joint tortfeasor who has been made to pay for the whole of the loss may not be guilty at all, and some other joint tortfeasor may be solely to blame for the wrongful act. In such a case, the guilty tortfeasor may fully compensate that one who has actually paid compensation. Thus, an innocent master can claim complete contribution from his servant for sorry whose negligent act had made the master vicariously liable to the injured party. The right of the indemnity cannot be claimed by a person who knowingly does or authorizes the doing of an unlawful act. W. H. Smith and Sons versus Clinton and Harris. Important case law. The earlier that we read of Meriwether versus Nixon rule, इसकी applicability क्या क्या है in India? ठीक है, वो देखते हैं हम लोग. ठीक है, applicability of the Meriwether versus Nixon rule in India. So, prior to abolition of this rule, the court in India had a conflicting opinion regarding the applicability of this rule. There have been numerous cases where this rule was followed. This rule doesn't comply with justice, equity, and good conscience, which was further abolished by the Court of England and was rightly rejected from being applied in several courts in India. Now, this is written in Hindi. आप पढ़ना चाहे तो आप एक बार देख सकते हैं हिंदी में भी. Consent obtained by fraud. R. was Williams 1998. R. versus Williams 1998. The defendant was a music teacher था, who raped his 16-year-old student by stating that the act would improve her voice. She gave her consent but didn't understand the purpose of the sexual act. The court didn't excuse the defendant because he obtained consent. After all, it was obtained fraudulently. Next, we have a look. Hall versus Brooklands Auto Racing Club 1993. सेम थिंग इज रिटन इन हिंदी ऑल्सो. अगर आपको हिंदी में एक बार देखना तो आप यहाँ से देख सकते हैं. ठीक है, अगर कोई आपको वर्ड समझ में ना आए तो. नाउ इन हॉल वर्सेस ब्रुकलैंड्स ऑटो रेसिंग क्लब 1933 में क्या हुआ था? Plaintiff was a spectator at a motor car race. During the race, there was a collision between two cars. दो cars के बीच में collision हो गया. One of which was thrown among the spectator, thereby injuring the plaintiff. No such accident occurred in previous 26 years. पिछले 26 सालों में ऐसा कोई इंसिडेंट या एक्सीडेंट नहीं अकर हुआ था. Held that plaintiff impliedly took the risk of such injury, the danger being inherent in the sport, which any spectator could foresee. Next case law, Padmavati and Ors versus Dughaneka and Oates, 1974. Two strangers voluntarily took a lift in jeep, aloof a sudden due to some mechanical defect. Mechanical defect it was. ठीक है? The jeep dropped and they suffered injuries. The driver and the owner of the jeep were sued. The court held that since the plaintiffs willingly, plaintiff की इच्छा थी, took the lift and the accident wasn't reasonably foreseeable and defendants were not liable. Next, very important legal terminology. Volenti non fit injuria. Volenti non fit injuria, which means defense of the consent. Defense of the consent. The harm voluntarily suffered doesn't constitute the legal injury. No man can enforce a right which he has voluntarily suffered doesn't cause the legal injury. Maxim has double application. It covers intentional and accidental harms. Intentional and accidental both kind of harms are being covered in this. Okay? Here is a codification which means justification or grounds of immunity from liability to an action in tort. Excuse अपने tortious liability को justify करने के लिए देना. नेक्स्ट वी हैव लिमिटेशंस. लिमिटेशन मीन्स कहाँ पे ये डिफेंस नहीं लिया जा सकता, कहाँ पे ये डिफेंस नहीं लिया जा सकता. जैसे इलीगल कंसेंट, कोई भी कंसेंट जो कि इलीगल हो वहां पे नहीं ले सकते. जो नो कंसेंट कैन लीगलाइज्ड एन अनलॉफुल एक्ट. अनलॉफुल एक्ट. ब्रीच ऑफ स्टैट्यूटरी ड्यूटी. देन वी हैव नेग्लिजेंस. नेग्लिजेंस में भी नहीं लिया जा सकता. फॉर एग्जाम्पल केस लॉ क्या है? ब्रैडन वर्सेस ऑसबोर्न स्काईलाइट केस. क्या कौन सा केस के नाम से इसको और जानते हैं? स्काईलाइट केस के नाम से जानते हैं. प्लेंटिफ्स husband and wife were in a shop. A skylight in the roof was broken. Owing to the negligence of the contractors, the glasses fell and injured the husband. His wife, while trying to pull him, strained her leg, held that both the plaintiffs were entitled to damages. The wife was held entitled in as much what she did was, in the circumstances, a natural and a proper things to do so. Rescue cases. कौन से cases? Rescue cases. Plaintiff voluntarily takes a risk, even of a death, to rescue somebody from an imminent danger created by the wrongdoer act, a wrongful act of the defendants. Wrongful act of the defendants. He can't be met with the defense of voluntary non-fit injuria. Most important point, and please pay attention. He can't be met with the defense of voluntary non-fit injuria. In which case? Rescue cases. Injuria, Haynes versus Harwood 1935 केस लॉ. क्या होता है? द डिफेंडेंट सर्वेंट, डिफेंडेंट्स का सर्वेंट होता है, लेफ्ट अ टू हॉर्स वैन unattended in a street. A police constable, the plaintiff who was on duty, saw the runaway horses coming down the street. Seeing a grave danger to a woman and children, he took the risk and managed to stop the horses. But in the process, he was seriously injured. It was a rescue case. कौन सा केस था? रेस्क्यू केस था. And defendant was held liable. Defendant ही liable ठहराया गया. Unfair Contract Terms Act 1977 इंग्लैंड. हिंदी में भी आप देख सकते हैं इसको. सिमिलरली थिंग मैं इंग्लिश में समझाता हूँ इसको. स्मिथ वर्सेस चार्ल्स बेकर एंड सन्स. स्टोन क्वारी केस. इसको एक और नाम जानते हैं किस नाम से? स्टोन क्वारी केस के नाम से. क्या होता है इसमें? प्लेंटिव वाज अ वर्कमैन employed by defendant on working a drill for the purpose of cutting a rock by the help of crane. किसके हेल्प से? क्रेन के हेल्प से. Stones were being conveyed from one side to the other, and each time when the stones were conveyed, the crane passed over the plaintiff's head. Pay attention, plaintiff's head. While he was busy in work, stone fell on his head. Defendant were held liable. मेरे knowledge of the risk isn't sufficient. ऐसा जरूरी नहीं है कि अगर नॉलेज हो रिस्क का तो वही जरूरी है, लाइक दैट इज ओनली सफिशिएंट. नो, इट्स नॉट एट ऑल. नेक्स्ट केस लॉ देखते हैं. डैन वर्सेस हैमिल्टन, ड्रंकन ड्राइवर केस. मोस्ट इंपॉर्टेंट केस लॉ, ड्रंकन ड्राइवर केस से भी इसको हम जानते हैं. 1939 का केस है. A lady knowing that the driver of the car was drunk. यहाँ पे गौर करने वाली बात क्या है? A lady knowing, उसको पता था ये बात कि the driver of the car was drunk, chose to travel, उसने खुद चूज किया to travel in it instead of omnibus, ओमनी बस से ट्रैवल करने के बजाय उसके ड्राइवर के साथ ही ट्रैवल करने का उसने चूज किया. ड्यू टू द ड्राइवर्स नेग्लिजेंट ड्राइविंग एक्सीडेंट वाज कॉज्ड, क्योंकि द ड्राइवर वाज ड्रंक तो इट कॉज्ड द एक्सीडेंट. ड्राइवर डाइड एंड कॉजिंग इंजरीज टू द लेडी, उसी लेडी को इंजरीज हो गया लेकिन ड्राइवर वाज डाइड. शी वाज हेल्ड एंटाइटल्ड फॉर कंपनसेशन. दिस डिफेंस wasn't applicable because the degree of intoxication of the driver was not to such an extent that taking a lift would be deemed to be consenting to an obvious dangers. Obvious dangers. Consent obtained under compulsion. The consent that is obtained under the compulsion. मजबूरी में प्राप्त सहमति. Essentials, आवश्यक. क्या क्या आवश्यक है? फ्री कंसेंट. इट इज मोस्ट इंपॉर्टेंट कि सामने वाले का कंसेंट फ्री हो. नॉलेज, साइंटी नॉट फिट इंजूरिया, वन ऑफ द मोस्ट अगेन इंपॉर्टेंट लीगल टर्मिनोलॉजी, साइंटी नॉन फिट इंजूरिया, विच मीन्स मेरी नॉलेज ऑफ द रिस्क इजेंट इनफ. केवल उस नॉलेज ऑफ द रिस्क यानी रिस्क की नॉलेज ही सफिशिएंट नहीं होती. क्या? रिस्क की नॉलेज ही केवल सफिशिएंट नहीं होती जानना. ठीक है.